Good afternoon, everyone. We'd like to welcome you and thank you for joining our webinar, Avoiding Immigration Violations. A quick note before we get started. Please feel free to submit questions at any time during the presentation using the chat feature on your screen. We will respond immediately to any technical concerns, and any other questions you have about the information being presented will be answered as soon as possible after the presentation. And without further ado, here is Ashley Kaplan, our in-house senior employment law attorney. Ashley has been practicing labor and employment law for more than 20 years. Here at Coast Guard, Ashley handles our legal compliance and also oversees the teams responsible for researching all the posting laws and developing compliance solutions to meet our customers' diverse needs. Ashley has agreed to personally follow up with a response to any posting compliance questions you submit during the presentation. And as a special offer to our attendees today, she will also be available to provide a complimentary consultation about your specific posting compliance needs. If you're interested, please indicate that in the question box, and we will contact you to set it up. And now, here's our presenter, Ashley Kaplan.
Thank you, and welcome everyone. Today, we're going to go over some practical tips to help your business comply with immigration laws, including the I-9 process where it all begins. And I'm going to spend some time today on the most common mistakes, the mistakes you want to avoid. And these are the areas where employers get fined the most, where they run into the most trouble, and also the areas where I've seen my clients struggle when it comes to navigating all the legal requirements around employee work eligibility in general. And that goes for everything from completing the I-9 forms to reviewing employee documents to record retention and storage. There's actually a lot of issues and questions we get around that. And this is really an important topic right now because as immigration laws have evolved over the past couple of decades, they have placed more and more burden on employers. And then we're talking employers of all sizes, even small businesses. The burden is on you to distinguish between legal and illegal workers. And then at the same time, there's increased national attention on immigration issues that we've seen lead to more and more audits, more investigations, and even more raids on employers across the country. And we're not just talking about the traditional industries where we've seen this. So it's not just agriculture and hospitality anymore. We've seen these raids and investigations affect all types of industries. Also, as you've probably seen in the news, recent federal crackdowns on illegal workers have resulted in serious civil and criminal penalties against companies and business owners. And that includes a lot of business owners and management who think that they're following proper procedures. And that's usually the case. It's not always intentional. A lot of these violations are subtle, and a lot of business owners and managers just simply don't know how to comply. So today we're going to give you an overview of the major immigration laws that apply to all employers. We're going to go over I-9 basics and how to complete and store the forms. And we're going to talk about E-Verify, what it is, who has to participate, and the pros and cons of participating if E-Verify is optional for you. So we're going to talk a little bit more about that and who's required to participate and who has a choice. So when it comes to employing foreign workers, your responsibilities as an employer are defined by several federal laws, but the main ones are the Immigration Reform and Control Act and the Immigration Act of 1990. So overall, on a high level, these laws make it illegal for you to knowingly hire workers who are not authorized to work in the U.S. And they also impose civil and criminal penalties on employers or businesses who do so. These laws also require you to complete Form I-9, which is an employment eligibility verification form, to verify work eligibility or work authorization for every new hire. And this I-9 form serves as your proof that the employee showed the necessary documentation to verify both his or her identity and eligibility to work in the United States. And we're going to get into a lot more detail about the form in just a minute. But one thing that a lot of people don't realize, which is equally important, is that there are also strict anti-discrimination provisions in these laws that prohibit you from discriminating against applicants and employees on the basis of their national origin or their citizenship in the hiring process. So these same immigration laws that require you to distinguish between illegal and legal workers and complete I-9s also say that you have to treat everyone the same. You can't subject certain people or certain applicants or employees to higher scrutiny in the I-9 process or in the hiring process just because you believe they are foreign or of a certain national origin. You have to treat everyone the same. So every new hire has to complete an I-9 form, and then in the I-9 process, you have to accept whatever documents an employee chooses to present, from the list of acceptable documents on the form. As long as the employee's got the proper combination and they've, met the necessary requirements, you don't get to specify or, scrutinize or, treat people differently based on any assumptions or fears that you might have. In fact, you can't even specify which documents that you need. You can't require, for example, a passport or a green card. You have to just go by the documents on the list. And you also can't even request any additional documents beyond what is on that list, even if you have suspicions. So this is something a lot of people aren't aware of. If you go above and beyond what's required, you can be accused of illegal discrimination, and it's what's known as document abuse or over-documentation. So, and just keep in mind with everything we're talking about today that these laws apply to employers of all sizes, even if you just have one employee. So we're going to get into a little more detail on these to help you learn how to comply. First of all, just to back up, these immigration laws that we're talking about are enforced by the Department of Homeland Security, and the penalties for violating immigration laws include monetary fines and criminal sanctions. And the specific penalties really depend on the seriousness of the offense, as you can see on this slide. And the most severe penalties, including especially the criminal ones, come for knowingly or intentionally violating the law. So, as you can see, the stiffest penalties are given to employers who repeatedly violate the law. So, if it's knowing, it's intentional, and you have repeat violations, that's where you see the highest penalties and criminal sanctions. And when it comes to I-9 forms, the penalties for I-9 forms, we're just talking about the form itself. Each I-9 form that is not properly completed, retained, or presented if you get an inspection is counted as a separate offense. So just for your I-9 forms, the fines can really add up. Okay, so the best way to avoid these fines and penalties is to start with proper I-9 procedures. I can't stress that enough. Completing the form I-9 correctly is the single most important aspect of immigration compliance. When it's done right, your completed I-9 forms are your best proof of compliance, and they would be your key defense against any kind of government fine, investigation, penalty, or lawsuit. So, and that's true, even if all of your employees are legally authorized to work in the United States, like I said before, problems with the I-9 forms themselves can lead to penalties. So if you have, problems just on the forms themselves, but the employees are legally eligible to work in the United States, you can still be fined. So it's really important to get it right when it comes to these forms. Like I said, we're going to look at the specifics of the form, but first here are just the basics, and these are important. So first of all, as I said before, all employers have to comply with I-9 verification requirements, regardless of how many employees you have. And by law, you have to complete and retain an I-9 form for every employee you have who was hired after November 6, 1986. So the only exception where you wouldn't need an I-9 on the new employee is if we've had someone work for you that long where they were hired before November 6, 1986. And this is true, even if you know the person to be a U.S. citizen. You have to complete an I-9 for everyone. So even if you personally know the person, you grew up with them, you're their neighbor's child, and you know for a fact that they're a U.S. citizen born in the U.S. And eligible to work here, you still have to complete an I-9 for that person. When it comes to timing, the law requires you to have each employee fill out Section 1 of the I-9 form on their first day of work, on or before their first day of work. That doesn't mean you should be giving it to applicants. There has to be an actual job offer that's been extended and accepted before you can do the I-9. But at the very latest, it has to be done on the employee's first day of work. Then next step is you have to review the documents presented by the employee to establish their identity and their eligibility to work in the United States. And you have to record information about these documents in Section 2 of the form, and that has to be done within 3 business days of the employee's start date. So these timeframes are very important. Day 1 is the employee Section 1, and within 3 days of the employee's hire date is Section 2, where you have to review and record information about the documents. The next bullet here on this slide explains how long you have to keep the completed forms on file. The rule is you have to keep a completed I-9 form for 3 years after the employee's first day of work, or 1 year after the employee's last day of work, whichever is later. And we're going to go over this again with an example because I know it can be confusing and it's really important to get this right. So we're going to spend a little bit more time on that and go through some examples. And then finally, you're required to keep the completed I-9s for the correct time frame, and you're required to make them available for inspection upon request to an authorized U.S. government official. So if there's an ICE audit or an ICE investigation, if you're ever audited or investigated, you're required to have these completed Form I-9s on file and to produce them for inspection. And I'm going to get into more detail also on how to file and store the forms so that you would be prepared if that were to ever occur. Really quickly, before we get into actually how to fill out the Form I-9, I wanted to talk about what version of the form you should be using. The edition date on the current government-issued Form I-9, as of the date of today of this presentation, reads 03/08/13 in the lower left corner of the form. So it's a March 8, 2013 version. There are older forms that are still out there. If your forms are dated February 2nd, 09 or August 7th, 09, those were acceptable only up until May of 2013. So any employees that were hired after May of 2013, you should have been using this new version of the form, the current version of the form. Everyone was required to switch over at that point. So this is a question I get a lot. You don't need to go back and redo your older forms for employees that were hired before then, before May 2013. You're just required to use the current form at the time of hire. So for any employees that were hired before May 2013, it's okay that you still have their old forms on file. You don't have to redo them with the current version. It's based on when they were hired. And by the way, we are expecting an updated version of the Form I-9 to be released soon from the government. Back in November 2015, the Department of Homeland Security published a notice in the Federal Register basically announcing that the proposed changes to the Form I-9 are going into effect. The actual version right now has an expiration date on it. If you look in the fine print on the form, it expires March 31st, 2016. So we do expect a new form to come out before then. It doesn't always work that way, just a little disclaimer. Sometimes the government will extend the expiration date and they'll allow employers to use the old form for a while until the new one's ready. But it is slated for a mandatory update, and it is expected around the end of March 2016. So it's definitely something to be aware of in the coming months. Okay, now let's go over how to complete the Form I-9. So the form actually has 3 sections. The first section is the employee section. And like I said, this has to be completed on the employee's first day of work. The second section, Section 2, is for the employer. That's your section, and you have to complete that section within 3 business days of the employee's first day of work. Then Section 3 is also a section for the employer, and that is a section that's really only used in certain circumstances that we're going to talk about in a minute. It doesn't come up all the time. So as the employer, you are responsible for making sure that all of the sections of the I-9 form are completed properly and that they're done on time. And that includes the employee section. It's your responsibility to make sure it's done on time and that it's complete. So this slide shows you a current image of Section 1, the employee section, and there are actually instructions that come with this form telling the employee exactly how to complete it, exactly what must be completed in Section 1. And you have to provide these instructions to the employee. By the way, I also recommend for you to read those instructions. You should take a look at the instructions yourself. The representative on behalf of your business who's doing these I-9s and reviewing documents with employees, because you want to make sure you're not contradicting anything that's in the directions if you get questions. So basically in Section 1, employees are required to provide their name, their address, their date of birth. You'll see here there's a space for employee social security number. But this is really important. It's something I wanted to point out. And this is also in the instructions, so the employee would have this information as well. Even though there is a space for the social security number, employees do not have to provide a social security number as part of the I-9 process unless you are participating in the Department of Homeland Security's E-Verify program, which we're going to get into later in the presentation. So if you're not participating in E-Verify, the social security number is optional. Like I said, the employee instructions say that, so employees would know that. The instructions also say that the employee email address and telephone number are optional. So if those are left blank, that's okay. The employee is required to complete what's called the attestation block in Section 1, and that's the part where they have 4 choices there, and they need to designate using one of the 4 boxes to indicate what their work eligibility status is. So that part is very important. And then depending on what they check, there could be some additional information that they have to fill in here. And again, if you follow the form, you could see what information is required based on which one that they check. And then, of course, for Section 1, the most important part is to have the employee sign and date the form. Make sure that the employee has done that. Just a note here you could see in this section of the form, if necessary, if the employee requests it, you do have to provide assistance or a translator to help the employee complete Section 1 of the form. And the general rule is that you have to assist an employee if he or she cannot complete Section 1 independently, or if they request for the form to be translated. And if you do end up providing an assistant or a translator, you need to make sure that the block at the bottom of this page, at the bottom of this section, is also completed, where it says preparer or and/or translator certification. You have to make sure that certification has been completed. Okay, so this slide summarizes the most common mistakes employers make when it comes to Section 1. And again, the employee fills it out, but it's your responsibility to make sure it's right. So take a look out for these mistakes. First mistake is not requiring employees to complete Section 1 on their first day of work. And if there's an audit, these dates will be matched up against your payroll records. So this is critical, getting the timing right. Second mistake is accepting the form without an employee signature and date. The employee's signature on here, if you read in the small print, it's the employee is signing under penalty of perjury. And so that's really important. If you get a form that hasn't been signed, you need to get it back to that employee immediately and get the signature and the date. Because without it, the form might as well be blank. That's really the whole purpose of the section. The third mistake is accepting a form with missing or incorrect alien or USCIS number or admission number in the attestation box. So if the box that they've checked requires more information, which is right there on the blank lines, make sure it's been provided or go back to the employee to get it straightened out. The fourth one here is accepting the form with a wrong date or incorrect dating format. This is very common. Be sure to check the dates to make sure the employee has used correct dating format for the U.S., which is month first, then day, then year. And the reason this is really common is because in a lot of other countries, it's the reverse. The day comes first, then the month, then the year. So that can make a big difference. When May 1st could be 5/1, but if it's done 1/5, that obviously changes everything on the form. And finally, a common mistake employers make is rejecting a candidate because they have not provided a Social Security number. So remember that Social Security number is only required if you participate in E-Verify. So you don't have the right to reject or terminate someone for leaving that blank or not being able to provide it if it's not required. Okay, now we're moving on to Section 2 of the form. And the second step in the I-9 process requires you as the employer to examine and list the documents presented by the employee to establish the employee's identity and employment eligibility. And like I said, you have to review the documentation and fill out Section 2 within 3 business days of the employee's start date. So I always recommend that you complete Section 2 immediately after the employee completes Section 1, because that gives you a little wiggle room in case you have any discrepancies with the documentation. And of course things happen and you might need to look something up or ask questions or get an original instead of a copy. So you want to leave yourself some room. You complete Section 2 basically by examining the documents presented by the employee and then recording the document information in the appropriate columns on the form. And on this slide you can see a current image of Section 2 to see what it looks like. So keep in mind when you're completing this step, you need to allow the employees to select which documents to provide based on the list of acceptable documents designated by the DHS. And like I said, the documents are listed right there on the form, and we're going to take a look at that next. But the point is, there are a lot of documents listed. There are a lot of options, and you cannot tell the employee which ones they have to present. They get to decide that. Next, you have to review original documents, and you have to accept documents that reasonably appear to be genuine and belonging to the employee. So keep in mind, this is a pretty loose standard. You're not required to be an expert or to do any detective work. You just need to make sure that the documents reasonably appear to be genuine. And of course you need to check and make sure that the name matches with the person you've hired and that the photo is of the person standing in front of you who's presenting the documents. You also need to check expiration dates really thoroughly on the documents to make sure that they're valid and up to date. Next, you need to record the required information about each document on the I-9 form in Section 2, and that includes the name of the document, the document title, the issuing authority, the document number, and the expiration date, if there is one. You also need to fill in the employee's start date, which of course needs to match up with the date when the employee completed Section 1. So just be very aware of your dates. Then you need to make sure that you sign and date the certification section. And this is done by the person, your representative, who actually reviewed the employee's documentation. And there's also a space for that person to print their name and title. But make sure that that's been signed. And then finally, don't forget in this section to print the name and address of your business. Even though it seems tedious, leaving it blank is considered a violation, and a lot of employers skip that because they think it's obvious or it's not necessary, but it is required, so don't forget that. Before I continue on to the common mistakes with Section 2, I want to touch on the list of acceptable documents. So this slide shows the current list of acceptable documents that's printed on the I-9 form, and so this is what the employee sees, and this is what the employee has to select from. The purpose is for the employee to show proof of his or her identity and to establish work eligibility. So the form divides the documents into 3 columns. The documents described in List A are sufficient to establish both identity and employment eligibility. So if an employee shows you one of these from List A, that's all they need to do. That's all they need to produce. The documents in List B only establish identity, and then the documents in List C only establish employment eligibility or authorization. So if an employee doesn't show you a List A document, they're going to need to show you both a document from List B for identity and C for eligibility. And by the way, even if an employee volunteers to give you more documents than are needed, don't accept anything more than this combination. Otherwise, it could be perceived as a form of discrimination, like we talked about, document abuse or over-documentation. Even if you didn't intend any harm, even if the employee volunteered it, don't accept any more than what's required. So if you get a document from List A, you do not need and should not accept something from B or C as well. A is enough. Also, while you're reviewing this slide, I want to mention that although you're not required to, you may choose to make photocopies of the employee's verification documents. And keep in mind that if you do make copies, it is not a substitute for completing Section 2 of the form. I know all the information would be in your copies, in terms of the issuing agency, the document number, but you still have to fill in the form and record that information on the I-9 form, even if you have a copy attached, a copy of the document attached. Also, when it comes to making copies, employment attorneys and HR experts disagree on whether it's best to keep photocopies. There's a lot of debate around that. Because, like I said, it's not required, it's just an option. But I think it really depends on the business and your culture toward compliance. I would just say that if you are keeping photocopies, make sure you're diligent with your record-keeping practices and, make sure you're confident that you have all your ducks in a row in terms of consistency and avoiding over-documentation. So if you do decide to photocopy the documents and keep them, make sure you're doing it for all your employees, so be consistent. Also, make sure that you limit the copies to the specific documents required for I-9 purposes. Again, nothing more than the form required, but nothing less either. Also, if you're copying them, make sure you copy the front and the back of the documents. And in terms of just where to keep them and how to file them, you would just want to store them along with each employee's completed I-9 form. So, in the same location, sort of as an attachment, whether it's electronic or in paper. So here are the most common mistakes to avoid when it comes to Section 2. First, there's recording more documents than are required. For example, more than one document from the same list. Second is listing documents in the wrong columns. It's important to put them where they go. Third is requiring specific documents, like requiring a green card or a Social Security card. You just have to remember it's the employee's choice. Fourth is recording foreign passport information from List A without the required accompanying document information. So as you can see on the form, if you're using a foreign passport in List A, the form tells you that what's required next to that, so don't leave it blank. And then along similar lines, number 5, is accepting a Form I-94 without a foreign passport to satisfy List A. Again, follow the form and you would see that these go together. Number 6 is not recording the employee's start date, so don't ever leave that one blank. 7 is completing or dating Section 2 more than 3 days after the employee's indicated start date. 8, which is very common, is leaving out document numbers or expiration dates, especially if you have photocopies. A lot of people think you can leave that out, but you can't. And then finally, the last one is just not including the name of your own company's business and business address. Like I said, a lot of people think that's not required, but it is. Okay, so let's move on to Section 3 of the I-9 form. You should only really be completing Section 3 of the form when re-verifying expired employment authorization documents or in certain situations when you've rehired an employee. So let's start with rehire. If you rehire an employee within 3 years of the date when the original I-9 was completed, you have the option of completing a brand new I-9 form, or you can just complete this Section 3 of the most current version of the I-9 form. So if an employee has a break in service and more than 3 years go by from the original I-9 date, you have to complete a whole new form. But if it's less than 3 years from the original I-9 date, you can just complete this Section 3 like an update. More frequently, more commonly, Section 3 is used for re-verifying your current employees if they have any work eligibility documents that have expired. So this is where you verify that you've reviewed the employee's updated or current documentation, and then you confirm or attest that that employee is still eligible to work. So one thing to keep in mind here that's important, you do not have to re-verify List B documents. Because remember, List B are the ones that just establish identity. They don't have to do with work authorization. So you don't have to re-verify, for example, employee driver's licenses. If someone presented a driver's license for List B, you don't have to go, record the expiration date and go back and get re-verification every time driver's licenses are expiring. Also, you don't have to re-verify for U.S. citizens and nationals or lawful permanent residents who presented a permanent resident card, which is a Form I-551. Even though that's a List A document, that's another exception. So for re-verification, the employee has to present a currently valid document from List A or List C. So again, they're trying to reestablish work authorization. And just like in the initial I-9 process, you cannot specify which document the employee has to present for re-verification. They get to pick from that list, and they don't even have to show the same combination of documents or the same document that they used originally that expired. As long as they can satisfy the work authorization requirement, either from List A or List C, with documents that are not expired, that's fine. That's all that's required. So remember to always complete the re-verification on or before the date the employee's work authorization document expires. So this means you should have a system in place for tracking expiration dates and reminders for upcoming re-verifications. You can do it electronically. A lot of people have set up a system electronically with calendar alerts. But if you store your paper forms in like a file folder or a binder, another idea is to tab the forms that have upcoming expiration dates and list them by date on like a separate re-verification schedule. Also, another tip, be sure to give yourself and your employees some lead time. I think it's a really good idea to give employees at least 90 days notice of upcoming expirations because the DHS typically takes up to 90 days to process applications for work authorization. So you want to give adequate time. It's not a legal requirement, it's just a good idea. So this slide shows some of the common mistakes employers make when completing Section 3. And I'm not going to spend a lot of time on this because we've gone over them. But the first one is the most important, and that is just failing to re-verify on time and allowing someone to continue working for you if they have an expired status. So, if an employee can't provide you with proof of current work authorization, and they had an expired document, you shouldn't continue to employ that person beyond the expiration date if you want to avoid an immigration violation. It's something you have to be disciplined about. Okay, so now that the I-9 form is completed, what should you do with it, and how long should you keep it? The DHS doesn't require you to submit completed I-9 forms to the agency. You don't have to file these forms, but there are strict record-keeping requirements in terms of how long you have to keep them and that you have to make them available for inspection if you're audited. So again, the general rule for how long to keep the form is 3 years from the employee's first day of work or 1 year after the employee's last day of work, whichever is later. So that means you're going to have I-9 forms on file for all of your current employees, unless, of course, they were hired before November 1986. And then you're also going to have completed forms on file for every employee who has left your company within the past year. But it's not always that simple. So the example on this slide demonstrates how you would calculate the retention period for someone who no longer works for your company. So you basically compare the two dates. And then, whatever yields the later date or the longer period, that's the date that you have to follow. You hold on to that form until that date. After that, you want to shred these forms and get rid of them. Otherwise, you can be liable for any problems with those forms or those employees if you get audited, even though you weren't even required to keep them. So record retention, having a system in place is really important. One of the biggest mistakes employers make, I think, is to store their I-9s in the employee personnel files. So first of all, that makes it hard to have any kind of system in place for expiration dates of documents and also to know, when you can throw away or destroy the forms. But also, it's just not a good idea. If you get audited and you're asked to turn over all of your I-9 forms, you really want to avoid giving documents that you don't have to give. You don't want to hand over entire personnel files. So, that could open you up to exposure for things that aren't even related. If there's compensation information or problems with, medical privacy, who knows what could be found in these employee personnel files. So you really want to keep the I-9 separate so you could easily produce them in an audit and have an easy system for purging old records. By the way, also, employers have the option to store I-9 forms in paper form or electronically. So even if you do your forms electronically, which a lot of businesses do now, keep in mind that you still have to have someone review the employee's documents in person. The original documents have to be presented by the employee in person to an authorized representative of your company. And that's the person who's going to sign off in Section 2 that they reviewed the documents physically and in person. Okay, this slide provides a great self-audit checklist to help you audit your own forms, your existing I-9 forms that you have on file. And a quick audit like this can really go a long way toward minimizing fines and risks of liability. Researchers have reported that, in looking at a typical business with I-9s, that there are usually errors on about 50% of I-9 forms. And I can tell you in my personal experience helping clients with I-9 audits and preparing for immigration audits, I would say that number is a lot higher. In my experience, it's closer to 75 or 80% of the forms that have errors or mistakes. And most of the time, employers are not even aware that they have any problems. And like I said, this is a serious issue because each mistake can result in a penalty. So usually if you're doing something wrong, like leaving out your own address, for example, you're probably doing the same thing wrong on all of your forms, so it can really add up. So this slide is really just a review, so I'm not going to repeat all the steps that we've gone over, but just keep in mind the main objectives of a self-audit are to identify and fix any kind of mistakes or blanks, omissions. You also want to make sure you eliminate old records that you're no longer required to keep. And then, finally, the most important is to make sure you're not inadvertently employing an undocumented worker. So, if you had an expired document, you want to address that. When you're cleaning up mistakes or blanks or, making changes to an I-9, it's okay to go ahead and make the changes or the edits right there on the form, or you can attach a correction sheet if you prefer, but do not backdate the changes. And don't cross things out so you can't read what's underneath. And also, don't use correction fluid like that liquid whiteout to cover up mistakes. You need to show a trail of what's happened. And then it's also best to just initial and date your changes. You can also write self-audit next to the change. This all shows good intent. These aren't going to be used against you if you've gone back and fixed mistakes, even if you had it wrong in the first place. So if you're doing a self-audit and you find that you're missing an I-9 form for someone, go get it completed. Get the employee the Section 1 and go ahead and get the documentation, review it, and complete that form, even if it's an existing employee that you've known for years. If you discover in your audit that someone's working without the proper documentation, whether it's missing from the form or it's expired, go immediately ask the employee to provide the documentation. And then in either case, if the employee cannot present the proper documentation within a reasonable time frame, then that's a decision you need to make. If you want to avoid immigration violations, you should no longer employ that person. If you do nothing about it, you're risking penalties for knowingly continuing to employ an unauthorized worker if that individual is in fact not authorized to work. So, okay, let's switch gears a little. Now that you know everything about the actual Form I-9, let's talk about the E-Verify program. And E-Verify is one way to help prevent violations for hiring illegal workers. For some employers, it's mandatory. For others, you have a choice whether to participate, and I'll cover that in a minute. So first of all, what is E-Verify? E-Verify is an internet-based system, and it's operated by the government, the U.S. Department of Homeland Security. And it allows employers to check an employee's eligibility at the time of hire during the I-9 process. So through its database, it's running a cross-check with the DHS records and also the Social Security Administration's records to determine if an employee is eligible to work in the U.S. So basically the E-Verify program gives you that added security beyond the I-9 process to check someone's eligibility. And by the way, just like everything we've talked about today, if you use E-Verify, you have to do so consistently to avoid discrimination claims. You still have to treat all your employees the same way in the verification process. So, for example, you can't only put certain workers through the E-Verify check just because you suspect that they may not be authorized. If you're doing E-Verify, you got to do it for all your new hires. Also, you want to, obviously make sure you're doing it consistently without regard to someone's apparent work status, national origin, their accent, their citizenship, any of those factors. Don't take those into consideration. Also, I want to clarify that E-Verify is not a substitute for the I-9 forms. It's supposed to be used in conjunction with the I-9 documentation process. It does not replace it. So you still have to have every new employee complete Section 1 of the I-9 form on or before their first day of work. You still have to review their documentation in person within 3 days, and you still have to certify on the form that you've done so. Actually, you use the information straight from the I-9, from Section 1 and 2, to start an E-Verify search on an employee. So you have to input that information from the form. And also, another requirement is that you have to run the E-Verify check within the 3 days of the employee's start date. So, most employers work it into their I-9 processes, and run the E-Verify check as they're completing Section 2. As soon as they're receiving that form from the employee with the information from Section 1. And then just like the I-9 form, you cannot use E-Verify for applicants. You have to wait until an employee has actually accepted a job offer. Again, technically you could do it before the employee starts work, but only if there's been an actual job offer and it's been accepted. So E-Verify is intended for new employees at the time of hire. For your existing employees, the only time you can do an E-Verify check on someone, if they're an existing employee, is if you become covered by a new federal contract that requires it, or if you're re-verifying an employee who had a temporary work authorization. A little more about the program itself. More than 500,000 companies now use E-Verify, and a lot of employers are required to participate, which I'm going to cover in a moment. But overall, about 1/3 of all the participants are doing so voluntarily, which a lot of people are surprised to hear. And you also might be surprised to hear how many small businesses are participating. When you include both the mandatory and the voluntary participants, out of all the users, about 23% have fewer than 20 employees. So, and wrapping up all the numbers, about 90% of the users are companies with fewer than 500 employees. Of all of the employees who are checked through E-Verify, 98.8% of work-authorized employees are automatically confirmed instantly or within 24 hours. So it works pretty quickly. And then in that case, that requires no further action on the part of the employee or the employer. When there are issues with a person's work authorization, which is rare, it can take a little longer, and that's actually one of the struggles that the agency is constantly trying to improve upon. It's one of the complaints that participants have that's being worked on. So this slide shows you state by state whether you're required to participate in E-Verify. And the first line shows you the list of states where all employers must participate, regardless of your company size or your industry. It's simply required for all employers in these states. And by the way, these state laws on E-Verify are quickly evolving. These laws, there's a lot of pending legislation, and they do change from time to time. So if you're opting not to participate, you might want to check with a local employment law attorney, or check the DHS website in your area just to make sure it hasn't become mandatory or required for you. Also, you'll notice on this slide I've included an asterisk next to a couple of the states, and this is because technically employers in those states are allowed to use an alternative to E-Verify. But the requirements are so similar that most employers in those states choose to use E-Verify. It's established, it works, it just makes it easier to comply. So those are lumped in with the other mandatory E-Verify states. The chart shows, also if you're a public sector employer, a government employer, you have to participate if you're in certain states. And then this note on the bottom is really important. Regardless of your state, you are required to participate in E-Verify if you are a federal government contractor, meaning that you have contracts with the federal government for goods or services, or that you receive federal funding. Or if you're a subcontractor with the E-Verify clause in your contract. And then finally, all federal agencies are also required to participate. So as I've mentioned, about a third of the participants who use E-Verify have chosen to do so voluntarily. And as with any decision, there are pros and cons. I've tried to kind of capture some of the main reasons why we hear that employers choose to participate when they have a choice. And then on the next slide, some concerns that employers have that where sometimes they choose not to participate. So just to highlight a couple of these, one reason a lot of companies choose to participate is that, for consistency. Maybe you have locations in states that are required to participate, and then other locations in states where it's voluntary. So just to be consistent, a lot of employers will just go across the board and implement it for all their locations. Another reason a lot of employers report participating is to get ahead of the law. Like I said, these laws are constantly evolving. A lot of employers are going ahead and participating just to be safe and not have to worry about watching the changing laws or monitoring it, or having to rush around and learn how to comply when it does become required. A lot of companies feel it's inevitable that this is eventually going to become a national requirement, so why not get on board early and get comfortable with it? So probably the most common reason I hear from clients who choose to participate is peace of mind. Employers often feel helpless and worried when it comes to all the immigration laws, like an open target. When you consider that you're just using a traditional I-9 form, you're not an expert in these forms, it does leave a lot of room for error. So, a lot of companies feel that using E-Verify for new hires is really the only way to get peace of mind by confirming that the data that the employee has provided actually matches up with the data that the government has on file. Of course, there's still room for error, and some unauthorized workers will still pass through the E-Verify check because maybe they're using someone else's valid information. The information's good. It might just be belonging to a different person. But using E-Verify will definitely minimize that risk. I also want to caution you here when we talk about peace of mind that E-Verify participation is not a safe harbor that automatically protects you from a government audit or immigration penalties. It's just one step you can take to reduce the likelihood of employing undocumented workers. Okay. I'm going to skip down the bullet on here about the rebuttable presumption, and this is, I think, a significant benefit, a reason why a lot of employers choose to participate. Employers who use E-Verify benefit from what the law calls a rebuttable presumption, that they did not knowingly hire an unauthorized worker. So, like I said, it's not a safe harbor protection. It doesn't exempt you from fines if it turns out that you did hire an unauthorized worker, but it definitely will help if you, in the event that an employee is determined to lack work authorization. So if you ran that employee's data through E-Verify and you were told that that employee was authorized to work, and so long as no other information came into you, that nothing else was revealed that should have caused you to question it, then you can't be charged with a knowing hire violation. And those knowing, when it's done knowingly, those are the violations that can lead to the highest penalties and even criminal sanctions. So if you follow E-Verify, you follow the results, and you don't have other information that would lead you to believe that the person is illegal, that will protect you from the higher penalties for knowingly hiring an illegal worker. Okay. Some of the negatives, or the reasons why a lot of companies choose not to participate. Well, first of all, E-Verify is free, but when you consider the resources that it takes to implement, some businesses feel that it's just too burdensome to take on. And this really depends on your company's resources, whether you have all the equipment and the technology to easily adapt to an internet-based tool in hiring, the level of sophistication or your comfort level with technology, or for the people you have on staff who are handling this. And this comes out of user surveys, and it really just depends, I guess, on your level of sophistication and what you're currently using. Let's see, the last one, near, toward the bottom, is that It's also another resource issue in terms of time and internet availability. You have to complete the I-9 forms on time. You don't get excused if there's something wrong with the system or it's slow. And internet accessibility can be a big thing if you're an organization that's hiring a lot of people at once, or you're going through a lot of changes. You still have to get that done within 3 days. So it sounds simple, but it can really come down to crunch time a lot of times, considering that during that same 3-day window, that's all the time you have to gather, review, gather all the documents, review them, record all the details from the employee's documentation. So, if you're hiring a lot of people at one time, it really just multiplies, and sometimes it's, difficult or impossible to get it all done within that 3-day period. And then just finally, the government does track the information that employers submit via the E-Verify system. So when you're using E-Verify, you're effectively providing I-9 data to the government that the government wouldn't otherwise have access to unless it went in and audited your papers in person. So this allows the government to see information from lots of employers and compare it. So if 10 different people are using the same Social Security number and working for 10 different employers, the government may notice that trend and investigate. That's part of the point. So in this kind of scenario, while you're probably not going to face any consequences relating to that individual, you haven't done anything, that's the employee who is trying to work the system, you still might find yourself tied up in an investigation, an immigration investigation. And of course that can be time consuming and stressful and even expensive, even if you haven't done anything wrong and there are no violations. So that's also something that a lot of employers take into consideration, and one reason I hear a lot why employers choose to stay out of the system or private. But that's just one factor to consider. So one of the things that's often overlooked with the E-Verify program is the mandatory posting requirement that comes along with it. There are actually strict posting requirements, the mandatory postings that you have to display at all your locations, and if you're an E-Verify participant. And the posting requirements apply for all E-Verify participants, whether you're participating because you have to or because you've chosen to voluntarily. And I know that seems counterintuitive, but the posting requirement is mandatory even if your participation in the E-Verify program is voluntary. So what are the posting requirements for E-Verify participants? There are actually 2 posters that are required. There's the E-Verify participation poster and the right to work poster, which a lot of people call the E-Verify discrimination poster. Both of these posters have to be posted in English and Spanish, and that's true even if you have no Spanish-speaking employees. And these posters have to be displayed in both languages near the entrance where applicants can view them. They have to be visible to applicants and employees. So, to comply, a lot of companies will just post these near an entrance to cover applicants and employees, but don't forget the applicant requirement. And by the way, the agency actually releases these posters in multiple languages. I think it's available now in 17 different languages. But the only languages that you're absolutely required to post them in for now are English and Spanish. I do want to tell you a little bit more about the E-Verify posting requirement and how to keep on top of it with a solution by PosterGuard. But I realize that some of you on the webinar today might not be familiar with PosterGuard, so I just want to take a minute to give a high-level overview of the program and how we cover all of the posting requirements, E-Verify and all the other posting requirements that you have to keep up with as an employer. PosterGuard is a comprehensive labor law posting solution developed by the industry leader in posting compliance for more than 25 years. And the way the service works is we start you out by sending all of the mandatory federal and state labor law postings for each of your locations. So depending on your state, just to comply with federal and state posting laws alone, you are required to post anywhere from 9 to 21 postings at each location. And in some cases, you have to post in multiple areas within your business, within the same facility, to make sure that the posters are readily accessible to all employees. And then on top of that, and those are your federal and state requirements, There are additional labor law postings that are required if you're in certain industries, if you have federal contracts, or if you're located in certain cities or counties. There are additional employee notices to post. So the post-regard posters are combined and printed on in a condensed laminated format, and this is to save on wall space, but also to ensure durability for compliance reasons. And by the way, we do realize wall space is it's important. It's at a premium, and we do shrink the posters down as much as we possibly can, but never to the point where it compromises compliance. A lot of these posters have minimum size font requirements, and I know it would be nice to shrink them down and make them near invisible, but we go as far as we possibly can without compromising compliance. And then the way the program works is once you get your initial mandatory postings, we take care of everything from there. So our in-house legal team, we have a dedicated legal team that researches and monitors the posters, and we're monitoring them daily. And whenever there's a mandatory update, we immediately notify you about the change, and we automatically send you a complete replacement poster at no additional charge. And that is true, no matter how many changes there are throughout the year. So, these posters change a lot. On a state level, we see about 150 changes a year, and half of those require immediate mandatory replacements. In a single state, I've seen the most I've ever seen is up to 14 mandatory changes in a single year. But it really depends on the state. Some only get a couple of changes a year, others get 5 or 6. If you also are in a city with city requirements, that adds to how many changes you have to manage. But as a post-regard customer, you don't have to worry about keeping track of the changes or replacing your posters. We're doing all of that for you. Also, post-regard provides a 100% guarantee against government posting fines. And this means that if you're a post-regard customer and you receive a government posting fine and you've properly displayed the most recent version of the posters that we sent you, we take full responsibility for the fine with no caps. And just, in addition to the basic federal and state poster coverage, we have post-regard solutions for cities. We cover city-county, we cover Canada, applicant areas, industry-specific posting requirements, and we offer all of the different posting solutions in alternate formats, including, the physical laminated wall posters. We have binder formats for workspaces without walls. And, of course, we have electronic solutions with full tracking and acknowledgments to help you meet your obligations when it comes to off-site workers or, people who work from home or telecommuters. So if you would like any information about any of these expanded services or even the basic coverage, just indicate that in the chat feature as a question, and we'll be sure to follow up with you after the presentation. So back to E-Verify. When it comes to the E-Verify postings, post-regard also has you covered. So as a post-regard member, your basic federal and state service automatically includes E-Verify posters, both the Right to Work and the E-Verify poster in both languages, in any state where E-Verify is mandatory. So from that chart we looked at, we automatically include the E-Verify postings and all the mandatory replacements as part of our service automatically at no charge for any locations that are in those states where all employers have to participate. It's automatic. And the same thing goes for our public sector customers or government customers. If you are in any of those states that were listed where government employers have to participate, you're covered automatically if you have our post-regard service for the public sector. And that's just a version of post-regard that it's like an industry-specific version just for government employers. Because government employers have all sorts of unique posting requirements, both federal and state, so that it's its own version. Finally, if you are a federal contractor and you have our service, post-regard for federal contractors, which is another specific service that we developed just for employers with government contracts or government funding, the E-Verify postings are already included. They're automatically provided because it's required for you. Like I said, for federal contractors, these posters are required because E-Verify participation is required. And when we're talking about federal contractors, by the way, there are now up to 13 additional posters required for federal contractors, depending on what kinds of contracts you have. We're just talking about employee-facing posters. And that's on top of the regular federal and state postings that we already mentioned. So if you'd like more information about the federal contractor posting requirements, like I said, there are up to 13 mandatory posters. Just indicate that also as a question, and we'll follow up with you. We actually have a great white paper explaining the posting requirements and who they apply to, if you'd like more information. A little bit about the poster itself, the E-Verify Right to Work poster. Ours is a combination poster, so it contains both of the required postings, and it has them in English and Spanish, since that's mandatory to post, for everyone. And by the way, that's one of the things that's unique about PosterGuard. We always include foreign language postings at no additional charge if they are required for everyone. And this E-Verify posting is just one example, but there are actually 22 states, and also in Washington, D.C., that require certain postings to be posted in Spanish, even if you have no Spanish-speaking employees. So as a PosterGuard customer, we don't think you should have to ask for these or pay extra for these, or even to do the research to know whether you need them. They're mandatory for everyone, so they're automatically included to make sure you're in 100% compliance. So if you're already a PosterGuard member, there's nothing to worry about with these 22 states I mentioned, because these posters already appear on your English posters as part of your basic coverage. You'll also notice that we print the E-Verify and Right to Work postings on a smaller separate sheet, apart from the large all-in-one format posters. And this is to make it easier for you to comply with that requirement that it has to be viewed by applicants. So by printing it on a smaller separate panel, it makes it easier for you to post it near an entrance. This is also something we do, by the way, just as a courtesy whenever there's a mandatory posting that has to be posted near an entrance. Another good example besides E-Verify are the employee no smoking posters. There are, I believe, 23 states right now where employers are required to post no smoking posters, and some have really strict content requirements and layout requirements. You have to list the state statute and give information about that. But even though these posters are separate and they have to be displayed at an entrance, we include these at no additional charge with our federal and state coverage, and we will always print them on a smaller separate poster, on a separate panel. So you could just hang that one poster instead of having to post your whole entire large format employee postings at your entrances as well as your break rooms. We're just trying to make that easier. And just as a side note, there have been a lot of mandatory changes to this E-Verify Right to Work posting over the past few years. I think there have been 4 mandatory changes to the posting since it was first released. So you want to make sure that all of your locations have the latest version of the posting displayed. And if you're a PosterGuard customer, your locations in all those covered states, we already have received those updates as they were released. So there's nothing that you need to be concerned about or that you would need to contact us. When mandatory change occurs, we're automatically getting those out to your locations. If you have locations that are participating in E-Verify voluntarily as a PosterGuard customer, they're not in those states where it's required, where we're including them automatically, you would need to let us know that so that we could add that E-Verify posting service on for those locations too. You just need to let us know what locations are participating if it's beyond the mandatory ones. So that wraps it up. I hope you found this presentation to be helpful and informative, and hopefully you're walking away with some good information about the E-Verify program and really about I-9 compliance with some action items to help you stay in total compliance when it comes to immigration practices. And if you have any questions or you would like additional information about PosterGuard or any of the compliance issues that I've talked about today, please feel free to contact our compliance specialist, Sarah Santiago, at 954-970-5533, or you can reach Sarah by email at ssantiago@posterguard.com. Thanks again for attending today's presentation, and we hope you have a wonderful afternoon.
Thank you.